It's been 3.5 years since the JEA board made two fateful decisions, voting to privatize the public utility and to create what federal prosecutors now say was a criminal employee compensation plan. But the trial of the two men charged as masterminds could be delayed. Joining me today, Metro columnist Nate Monroe of the Florida Times-Union. Hey, Nate.
Hey, Ann.
Thanks for being here. And there is nobody outside of federal court who has a better grasp on all things JEA than Nate. So if you have a question about the case or the possible delays that lay ahead, give us a call at 549-2937. Tag us on X at FCC On Air or send an email to firstcoastconnect@wjct.org. You can also message us on Facebook and Instagram. So, Nate, those of us living in a news silo sometimes assume everybody knows this case through and through, but we forget that a lot of people aren't familiar with why these two JEA executives could be headed to prison. So what is this case all about?
Yeah, I mean, of course, we could talk about that for the entire hour. But, the sort of short version is that Aaron Zahn, when he was the CEO of JEA, and Ryan Wannemacher was his CFO, in 2019, they began and led an effort to sell JEA to a private operator, very likely another private power company. This would have been a transaction worth billions and billions of dollars. The top bid that JEA got was, about $11 billion. And what federal prosecutors say is that the two men, Aaron Zahn and Ryan Wannemacher, conspired to essentially skim a portion of those proceeds and pocket them for themselves. And this could have been, those payouts could have been in like the hundreds of millions of dollars. Now, both of them have pleaded not guilty to that. They were indicted in March of 2022. So we're actually going on 2 years since their indictment. And so this has been a slow moving case. And I fear that we will be talking about it for a long time yet to come.
And it dates itself to this very consequential vote in 2019. And now the attorneys or at least for one of the defendants, is asking for a delay of the case, a delay of the trial. That was a discussion I had earlier this week. You were there for it. Tell us what happened in court.
Yeah, so right now the trial is currently scheduled for February 5th. And for many months, I think the assumption has been, look, this has already gone on a while. We need to really try to make this February date happen. February is a good month to have trials because, you're sort of in between the holidays and spring break. So people aren't, typically traveling as much. And that helps in terms of like getting a jury pool. It helps with witnesses. But Aaron Zahn's attorneys on Monday at a status conference asked Judge Brian Davis for a 60-day continuance. So this would push us into April. The government very much vigorously does not want that. And I got the sense, and of course you were in the hearing too, and I think the sense we both had is that the government sort of lost patience with the defense and this kind of asking for another delay. I mean, I think that the hearing actually got a little bit snippy at points. And so, we'll see that the Judge Davis likes having written motions asking him to do things, and he likes to issue written decisions. He doesn't do a lot of stuff from the bench. So, we'll see how he decides that. I felt like seemed a little bit skeptical of the need for a 60-day delay, but he might show some, he might meet them in the middle. I don't know.
And the attorney that was making that argument said it was for personal reasons. So the prosecution basically said there's not like a legal reason to delay this case, which has been delayed. There was this lengthy hearing over the summer that we attended, you covered heavily, and all of that part of a case that has been, as the prosecutor said, really heavily litigated so far.
Oh, yeah. I mean, the hearing you referenced that took place over the summer was essentially a mini trial. It was an 8-day hearing that actually that lasts longer than a lot of trials do. Yeah, this has been heavily litigated. We've seen just like tons of what attorneys call motion practice, which is just the filing of different pretrial, arguments about this or that. I mean, again, the federal system can move very slow, and I think even by those standards, I mean, we're in like downtown development timeline territory here, right? Like I feel like I'm going to be in Fleet Landing before all the, these things that people talk about are going to get built. And this case is starting to feel like that too.
Yeah, the endless. They one thing that I thought was interesting that the prosecution mentioned is in future motions, and there are a lot of ones that are pending that we should talk about, but that they want a page limit. They said that after the Castigar hearing that happened over the summer, that the government received 530 pages of arguments just from that briefing that followed that long hearing.
Yeah, I mean the filings in this case have been like epically long, and page limits, just for listeners, I mean those are not unusual. Judges pretty frequently will tell the various parties, yes, you can file this, but it needs to be 10 pages or 5 pages. Those limits have not been imposed for a lot of the pretrial sort of debates that have arisen, and so I mean we've seen the defense file motions that were like 100 pages long, and that's, I mean, that generates a lot of work. There was also an irony, and I think the prosecutor pointed this out, that they're asking for a delay, and they do claim that there's been so much discovery in this case, and there's a lot of material, and so beyond personal reasons, there is a sort of a logistical need for a 60-day delay, and I mean, the prosecution's pointed out, well, you guys have been filing huge motions. I mean, clearly you're available to work. So why do we need to delay this? So yeah, it's interesting it's always interesting to see the lawyers kind of duke it out in front of a judge like that.
So there's some very consequential decisions that still need to be made. I'd be interested in your thoughts. So there's a request to move the venue out of Jacksonville. There's the continuance, obviously, that we discussed. There's a motion to sever the two cases. What give us a little quarterback on what might happen there?
Yeah, so Zahn's attorneys have asked the judge to move the case to Tampa. They also want, as you said, both defendants want separate trials. I think as an initial matter, motions like this are granted on a pretty unusual basis. Like, it's not normal for defendants to win these kinds of things. And so I think it's easy to just assume that they're probably not going to happen. Like, I don't think the case is going to get moved down to Tampa. And their argument kind of centers on this idea that JEA has gotten all this publicity, and that the public's view of Aaron Zahn is pretty solidified and pretty negative, and that it will be impossible to get a jury in Northeast Florida that can be truly open-minded about him. I am personally skeptical of that claim. I think that is assuming a level of awareness in the broader public that is rare for a local news story. And on the issue about whether they should be tried separately is a bit more complicated. And I think the one where there is likely to be, or likelier, the judge might actually weigh, if not two separate trials, maybe having two different juries hear the case. There are some complicated legal reasons behind a lot of that. But I would not be surprised if Davis simply said, nope, we're moving forward. It's been 2 years. We're going to have a clean trial, one jury in Jacksonville. Let's just get it moving. You can appeal that stuff after.
He even said, I mean, I don't know if this is tipping his hand, but he even said during the hearing this week, presuppose that I'm going to deny those motions. Then what? What's going to happen? What's the schedule? Are we on track? Yeah.
He was trying to get the defense to sort of, tell me when you'd be ready, and presuppose that I deny all these things. I mean, I agree with you. I think that tends to tip your hand a little bit.
I want to ask you just briefly about the cost of the defense in this. You've reported previously on the arrangement of who's paying for the legal defense. Talk about that and why that's a little unusual.
Yeah. And candidly, this is something I need to follow up on, because I have not revisited this in some time. But JEA at the time that Zahn and Wannemacher were employed had, and I think still has, a version of a director and officers insurance policy. And that policy essentially says that if at least the way that the insurance company is interpreting it, they are fronting money for Zahn and Wannemacher's defense costs and have been covering it. When I last looked at a ledger of costs that the insurance company is paying out, this was last year. I think they had already reached between the two of them into a couple $1 million between them. So it would be considerably more than that now, especially with all of these different motions that we've talked about and the hearing over the summer. So yeah, JEA's insurance company is paying for their legal defense right now. So ratepayers are not. Like, you're not putting up millions of dollars. The way that I think the concern on JEA's end might be that, their insurance premium might be higher going forward. And if, as I understand it, if they were to lose, if they were to be convicted, the insurance company can try to recoup that money. So it's not, this isn't like a free and clear thing. If they lose, the insurance company could come and try to recoup the money that they fronted, which would be a considerable amount of money.
So we've got a message from Tom on Facebook. He says, it's hard to believe with all the dishonesty surrounding the effort to sell JEA that former Mayor Lenny Curry and his aide Brian Hughes broke no laws themselves. Of course, neither of those men are charged in this case, but both played a big role in the sale effort, kind of out in front and then later a little bit more behind the scenes.
Yeah, I mean, I get a version of this question a lot, and, so it is, I mean, neither of those two have ever been accused of wrongdoing by the government in this case. And I mean, look, like, I am sympathetic to people's concerns that the former mayor was not forthright with the public about his desire to sell the utility and what he and his administration had done to sort of make that happen. But, lying to the public is not a crime. And prosecutors need very, very specific charges of wrongdoing in order to go after somebody. And I don't know, I've never seen any indication that the mayor was involved in this like sort of payout scheme at the heart of this case. I just think that's kind of the crux of it. Like, I think a lot of people believe that the mayor was dishonest, but, dishonesty is just not something that you can be prosecuted for. And, going after public corruption is very difficult. The Supreme Court has, over the last couple of decades, really narrowed the kinds of things that prosecutors can charge. And these cases are really tough. And frankly, it's kind of, it was unlikely that prosecutors built the case they built in the first place. I mean, this is not a slam dunk. This is, just what they're doing now represents kind of a riskier case than I assumed that they would take on.
Yeah, and it is kind of amazing that this ended where it did, given how close to reality all of this was. I mean, the sale process was accelerated towards the end. This PUP plan, this kind of convoluted benefit plan that could have enriched, according to prosecutors, these two executives and others, was already in place. So had the sale occurred, there really was kind of a mechanism where all of this could have been reality.
Yeah, I mean, I think this was all moving very quickly. One thing I do expect the defense will raise at trial is this idea that, of course, the sale never happened, and so they were never paid out. And I think one of the arguments they're going to raise is, look, the JEA board would have had to approve a deal. The city council would have had to have approved a deal. And ultimately, this was going to go to a referendum and voters were going to vote on it. And so, who are we to say that this was a sure thing? And yes, those things are true. Those approvals would need to have happened. But it's easy to forget the environment at that time, how quick this was moving, how much pressure would have been brought to bear on the board and on the city council to approve a deal. And then ultimately in a public, in a referendum, I mean, it's not like a campaign like that this isn't the point where the public would have some sober Socratic dialogue about the benefits of privatization. This was going to be, the winning bidder was going to inject millions of dollars in these hysterical, misleading ads I mean, that's what it would have been. I mean, that's how campaigns are done in this country.
Well,
So that's what it would have been.
Ratepayers were also being incentivized with thousands of dollars that they would also get in their bank account, kind of, if the sale happened.
Right. Yeah. I mean, that was sort of part of I think part of the strategy to get the deal done was that like everyone was going to get paid. You know, the city was going to get billions of dollars to play with. JEA employees were going to get paid out. The executives were going to get paid. Ratepayers were going to get either rebates on their bills or some version of like compensation. So it was kind of like this, and I think that, you know, to the way I would say, just kind of grease the wheels to get a deal done. Like that's what it all looked like to me at the time.
Nate Monroe, Metro columnist for the Florida Times-Union. Thanks so much always for covering this case as you have done and for coming on air to talk to us about it.
Of course.